The bailiff's voice cuts through the murmur of the courtroom. The court calls Patricia Taylor to the stand. I watch my mother stand, smooth her navy blazer, and walk to the witness box with the kind of confidence that comes from believing you're doing the right thing. She places her hand on the Bible, her expression solemn and appropriate. The oath administrator asks if she swears to tell the truth, the whole truth, and nothing but the truth. I do, she says clearly. Her voice doesn't waver. She doesn't glance at me, not even once, as she settles into the chair and arranges her hands in her lap. The plaintiff's attorney approaches with a warm smile, the kind that says we're all reasonable people here trying to get to the bottom of things. He asks her to state her relationship to me. I'm Harlan's mother, she says, and something about the way she uses my first name instead of saying my daughter makes my stomach tighten. This isn't going to be a character defense. This is going to be something else entirely. The attorney thanks her for coming, acknowledges how difficult this must be, and asks his first real question. And that's when my mother begins systematically destroying my reputation in front of a jury of strangers. Would you describe your daughter as emotionally stable? The attorney asks. My mother pauses, and I can see her carefully considering her words. Not because she's uncertain, but because she wants maximum impact. Harlan has always been intense, she begins. Even as a child, she had difficulty managing her reactions to disappointment. The jury members lean forward slightly. One woman in the back row adjusts her glasses. My attorney scribbles a note, but doesn't object. We knew this was coming. My mother continues, describing incidents from my childhood that she frames as evidence of volatility. The time I cried during a school play, the argument we had when I was 16, the time I changed jobs without telling her first. Each story is technically true but stripped of context, repackaged as proof of instability. She talks about my tendency to overreact, my difficulty accepting criticism, my pattern of blaming others when things go wrong. Every word is delivered with reluctant honesty, like she hates to say these things but feels obligated to tell the truth. The attorney nods sympathetically. The jury takes notes. And I sit perfectly still, hands folded, face neutral, watching my mother perform character assassination with the precision of someone who's been rehearsing for years. The judge writes something down. I notice because his pen moves only when my mother speaks, never during my attorney's cross-examination, never when my former colleagues testify. Just when she talks. He underlines whatever he's written. My attorney, Claire Westbrook, notices it too. I see her jaw tighten slightly, the only sign of her frustration. We prepared for my mother's testimony, knew she'd been contacted by opposing counsel, knew she'd agreed to appear. What we didn't prepare for was how convincing she'd be. She doesn't sound vindictive or angry. She sounds concerned, worried, like a parent forced to acknowledge painful truths about her child for the greater good. The plaintiff's attorney asks if I ever discussed my workplace conflicts at home. My mother says yes, and describes conversations where I apparently ranted about my supervisor, made accusations about favoritism, claimed people were conspiring against me. I try to help her see things from other perspectives, my mother says. But she wasn't interested in hearing it. Another juror makes a note. The judge's pen moves again. And I realize with cold clarity that I'm losing this case not because of evidence, but because my own mother has convinced this courtroom that I can't be trusted to tell the truth about my own life. My mother testified against me in court. The evidence, she had destroyed her credibility. My name is Harlan Taylor. I'm 34 years old, and until 6 months ago, I worked as a senior consultant at Bradford Solutions, a mid-sized firm specializing in corporate restructuring. I was good at my job. I had positive reviews, strong client relationships, and a reputation for thorough analysis. I wasn't perfect, but I was competent and professional. None of that matters now. What matters is that I filed a formal complaint about workplace harassment. My employer retaliated by terminating me, and when I sued for wrongful termination, my mother volunteered to testify against me. Not for me. Against me. That detail is important because it tells you everything you need to know about how we got here. This case isn't really about my job or my complaint or even about the money. It's about control. My mother has spent my entire life rewriting my story, reshaping my experiences into narratives that serve her version of reality. When I was younger, I didn't recognize the pattern. I thought all families worked this way, that all mothers corrected their children's memories and explained what they really meant and why their feelings were actually something else. I'm 34, and I'm only now understanding that my mother hasn't been documenting my life. She's been curating it. The pattern started early, though I didn't have words for it back then. Family dinners where my mistakes became teaching moments, dissected in front of siblings and cousins until the original incident disappeared under layers of interpretation. My mother never yelled. She never punished harshly. She just gently, persistently, relentlessly corrected my reality until I wasn't sure what had actually happened anymore. My younger sister, Bryn, never had this problem. When she made mistakes, they were understandable, forgivable, proof of her authentic personality. When I made the same mistakes, they were patterns, evidence of deeper issues, signs I needed guidance. The favoritism was subtle, but constant. Bryn's choices were brave. Mine were impulsive. Bryn's opinions were refreshing. Mine were argumentative. Bryn's career changes showed adaptability. Mine showed instability. By the time I was in my 20s, I'd learned that disagreeing with my mother meant hours of careful explanation about why I was misunderstanding my own feelings. It was easier to stay quiet, to let her narrate my life. Until this case forced me to choose between her version of events and the truth. I chose truth. She chose the courtroom. Bradford Solutions occupied 3 floors of a glass tower downtown. Clean lines, ergonomic chairs, motivational posters about teamwork and innovation. It looked like every other corporate office, felt like every other professional environment. I started there 5 years ago as a junior consultant and worked my way up through competence and consistency. My supervisor, Keith Brennan, was in his 50s, well-liked by management, skilled at client relations. He was also inappropriate in ways that were hard to document. Comments about appearance delivered as compliments. Questions about personal life framed as friendly interest. Standing too close, touching arms during conversations, sending emails late at night that had nothing to do with work. Each incident was small enough to dismiss. Together, they created an environment where I spent more energy managing his behavior than doing my job. I mentioned it to HR informally twice. Both times, I was told Keith was just old-school friendly, that I should be direct with him if something bothered me. I was direct. He apologized, then continued. So I started documenting. Dates, times, witnesses, exact words. 3 months of careful records. Then I filed a formal complaint, professional and detailed, requesting investigation and intervention. That's when everything changed. The complaint went through official channels on a Tuesday morning. I submitted it to HR, copied the required departments, and waited for the process to unfold. I was calm. I'd followed procedure. I had documentation. I thought the system would work. By Thursday afternoon, I noticed the shift. Keith was suddenly absent from meetings I attended. My projects were reassigned without explanation. Colleagues who used to chat with me at lunch started finding reasons to eat elsewhere. Friday, I was called into a conference room with HR and my department head. They wanted to discuss my complaint, they said. But instead of asking about Keith's behavior, they asked about my mental health. Was I under unusual stress? Had I considered speaking with the Employee Assistance Program? Did I feel I was managing my workload appropriately? The questions were gentle, concerned, completely off topic. I redirected back to my complaint. They nodded, said they'd continue investigating, and suggested I take some personal time to decompress. That weekend, I learned from a colleague that my mother had contacted the company. She'd requested a private meeting with HR, said she was worried about me, wanted to provide context that might help them understand my recent behavior. She gave them information without ever asking me what actually happened. The meeting with HR happened 3 days after I filed my complaint. My mother requested it personally, calling the main office and asking to speak with someone about her daughter's well-being. I found out later through discovery documents. She met with Pamela Norton, the head of HR, in a private office for 45 minutes. The meeting notes are sparse, Just phrases like family concerns and history of misinterpretation and mother-advised employee assistance program. But the effect was immediate. Suddenly, my complaint wasn't about Keith's behavior. It was about my perception of Keith's behavior. My mother positioned herself as a concerned parent with relevant background information. She offered context about my personality, my tendency to misread social situations, my pattern of creating conflict when I felt overlooked. She didn't present it as criticism. She presented it as help. This is who my daughter is, she told them. This is how she processes workplace dynamics. If you understand that, you can better support her. She was helping them help me. Except I didn't need that kind of help. I needed them to investigate my complaint. Instead, they investigated me. And my mother gave them the framework to do it. She wasn't protecting me. She was protecting her version of me. The version where I need guidance and correction and someone to explain my own experiences back to me. I discovered the written statement during the discovery phase of the lawsuit, months after I was terminated. It was buried in a file of HR documents, dated 2 days after her meeting with Pamela Norton. The statement wasn't long, just 2 pages, but it was detailed. My mother described incidents from my life that supposedly demonstrated a pattern of instability, times I'd quit activities as a teenager, arguments with former friends, jobs I'd left, relationships that ended. She framed everything as evidence of my difficulty maintaining stable situations. The statement included phrases like has always struggled with authority and tends to personalize professional feedback and history, suggests she may be misinterpreting normal workplace interactions. Each sentence was carefully worded, never quite calling me a liar but strongly suggesting I couldn't be trusted to accurately assess my own circumstances. What made it worse was realizing she wrote this without ever asking me what happened. She didn't call to hear my side. She didn't request a conversation to understand my complaint. She just contacted my employer, offered her expert opinion as my mother, and handed them ammunition to dismiss everything I'd reported. The statement ended with a recommendation that I be encouraged to seek counseling and that any workplace concerns be evaluated with consideration for my tendency toward dramatization. She signed it. She made it official. And she never told me she'd done it. Bradford Solutions terminated me 6 weeks after I filed the complaint. The official reason was performance issues, vague concerns about meeting deadlines, and communication problems with team members. The timing was obvious. The documentation was thin. My attorneys said we had a strong wrongful termination case. The company tried to settle early, offering 6 months severance if I signed a non-disclosure agreement. I refused. I wanted a record. I wanted accountability. So we filed suit, requesting compensation for lost wages, damage to reputation, and employer retaliation. The company responded aggressively, filing a motion to dismiss and claiming my termination was unrelated to my complaint. When that failed, they shifted strategies. They started building a case that I'd been a problematic employee long before I filed any complaint. They requested character witnesses. And my mother volunteered. She called their attorney directly, offered to testify about my history, said she wanted to help provide context. Their attorney was thrilled. My attorney was furious. I was numb. Because in that moment, I understood that my mother would rather side with my employer, a corporation she'd never met, than trust her own daughter's account of harassment and retaliation. The case wasn't just about my job anymore. It was about whether I had the right to my own story. I made a decision that surprised my attorney. When she suggested we try to exclude my mother's testimony, I said no. Let her testify. Let her say everything she wants to say. Claire looked at me like I'd lost my mind. Harlan, she's going to try to destroy your credibility. Why would we allow that? Because I'd spent my entire life being told my version of events was wrong, I explained. I'd been corrected, reinterpreted, and gently educated about what I really meant and really felt. If I fought to silence her now, it would look like I couldn't handle the truth. But if I let her speak and then systematically dismantled her testimony with facts, with documentation, with evidence she didn't know existed, it wouldn't just clear my name. It would end this pattern forever. Claire studied me for a long moment. Then she said, "Okay. But we're going to need everything. Every email, every text, every document that touches her involvement in this case. So, I gave her everything. And then I authorized our legal team to request something specific through discovery. Archived email backups from my mother's personal account, subpoenaed through the company's correspondence with her. It was a long shot. But if my mother had been coordinating with my former employer, if she'd been more involved than she claimed, there would be a record. And records don't lie the way people do. The discovery response came back with a gap we almost missed. Bradford Solutions provided extensive documentation, my personnel file, performance reviews, the HR complaint, witness statements, meeting notes. But several documents referenced email correspondence with external parties that weren't included in the production. My attorney filed a motion to compel, pointing out the missing communications. The company's attorney argued that external emails weren't relevant to employment decisions. The judge disagreed. He ordered production of all correspondence related to my complaint and termination, including communications with third parties. That's when my mother's emails appeared in the file. Not many, just 6 messages spanning 3 weeks. But the timestamps told a story their attorneys hadn't anticipated. The first email was dated the day after I filed my complaint. My mother had reached out to Bradford Solutions that quickly, offering to provide background information about me. She'd moved fast, getting ahead of the narrative before anyone investigated my actual claims. The messages showed ongoing coordination, my mother asking for updates on the investigation, offering additional context about my personality, suggesting specific ways to approach conversations with me. She'd been actively involved in shaping the company's response to my complaint. But there was a gap. 2 emails were referenced in meeting notes but not produced. The metadata showed they existed. The files showed they'd been accessed. But they weren't in the discovery packet. Someone had withheld them. We filed another motion. The missing email surfaced through archived backups that Bradford Solutions didn't realize existed. Their IT department had implemented a new email system 8 months before my termination, and the old server had been preserved as a backup during the transition. When the judge ordered a forensic review, those archived messages came back, including the 2 my mother thought would stay hidden. The first was sent 3 days before I was terminated. My mother had emailed Pamela Norton directly with a subject line, "Confidential. Additional concerns re. Harlan." The message was brief, but damaging. She suggested that my complaint about Keith might be part of a larger pattern she'd observed, that I'd made similar accusations at a previous job, that I had a history of perceiving bias where none existed, that I might be trying to create leverage for negotiation. Everything in that email was false. I'd never filed a harassment complaint before. I'd never accused anyone of bias at previous jobs. I'd never tried to leverage complaints for personal gain. But she wrote it with confidence, as if she had documentation, as if these were facts rather than fabrications. And Bradford Solutions used that email to justify terminating me instead of investigating my complaint. The second email was even worse. It was dated 4 days after my termination, sent in response to a question from the company's attorney about whether my mother would be willing to testify if the case went to trial. Her response: "Absolutely. I think it's important that the court understand Harlan's full history, not just what she chooses to disclose." We found the contradiction during trial preparation, buried in the deposition transcripts. My mother had been deposed 6 weeks before trial. Under oath, she testified that she'd contacted Bradford Solutions only after they reached out to her, that she'd been reluctant to get involved, that she'd simply provided honest context when asked. She said she'd had no ongoing communication with the company, that her involvement was limited to the initial meeting with HR and one brief follow-up. The attorney asking questions had been thorough but hadn't yet received the archived emails. So my mother's testimony went unchallenged in that deposition. She'd lied smoothly, confidently, probably believing those emails would never surface. But now we had them. And they contradicted every statement she'd made under oath. She hadn't been contacted by the company. She'd initiated contact within hours of my complaint. She hadn't been reluctant. She'd volunteered eagerly and repeatedly. She hadn't limited her involvement. She'd maintained ongoing communication and even strategized about my termination. Most importantly, She'd fabricated claims about my work history to justify the company's decision to fire me instead of investigating my complaint. One lie would have been enough to destroy her credibility. We had a pattern of lies, documented and time-stamped. My attorney looked at me after reviewing the emails and said, "This changes everything. We can impeach every word of her testimony." I nodded, but what I felt wasn't triumph. It was something quieter and sadder. My mother had lied to protect strangers, and she'd done it so easily. Back in the courtroom, I watched my mother testify with practiced sincerity. The plaintiff's attorney asks if she's proud of me despite our current situation. She pauses, a moment of visible emotion, then says, "Of course. I'll always love Harlan. I just wish she could see how these patterns hurt her." It's a perfect line. Several jurors look sympathetic. One woman dabs her eyes. My mother has positioned herself as the caring parent forced to deliver hard truths. Claire doesn't cross-examine aggressively. Instead, she asks clarifying questions, letting my mother elaborate on her version of events. "Mrs. Taylor, you mentioned you were reluctant to get involved in this case. Can you explain what changed your mind?" My mother nods. "I received a call from Bradford Solutions. They were trying to understand Harlan's complaint, and they asked if I could provide context. As a mother, I felt obligated to help them see the full picture." "And that was your only communication with the company?" "Essentially, yes. One meeting with HR, one brief follow-up. I wanted to stay out of it as much as possible." Claire makes a note, her expression neutral. "Thank you, Mrs. Taylor. Nothing further at this time." The plaintiff's attorney looks satisfied. My mother steps down from the witness stand, looking composed and credible. The judge calls a recess. And I know what's coming next. But my mother doesn't. During a lunch break, I notice my mother sitting with Bradford Solutions' legal team in the courthouse cafeteria. They're having coffee, talking quietly. She's smiling at something the lead attorney said. Her comfort with them is obvious. She's not conflicted about her testimony. She believes she's doing the right thing, helping them understand me, providing necessary context that will lead to the just outcome. When she sees me across the cafeteria, she doesn't look away. She meets my eyes with an expression that's almost kind, the look a parent gives a child who needs discipline but will eventually understand it was for their own good. That look tells me everything I need to know. She's not worried. She's not reconsidering. She's confident that her testimony has served its purpose, that the jury now sees me as she does, that this case will end with everyone understanding I was the problem all along. Her overconfidence is remarkable. She's so certain of her narrative that she hasn't considered any other possibility. She doesn't know about the emails. She doesn't know we requested the archived backups. She doesn't know that while she's been testifying about her limited involvement, we've been preparing a dozen documents that prove she's been lying under oath. She thinks she's won. And that confidence is going to make the next phase even more devastating. Court reconvenes at 2 o'clock. The judge asks if the defense has additional witnesses. Claire stands. Your Honor, we have one brief witness, then we'd like to recall Patricia Taylor for continued cross-examination. The judge nods. My mother's attorney looks confused, but doesn't object. My mother returns to the witness stand with the same composed expression. Claire approaches with a folder. Mrs. Taylor, you testified this morning that Bradford Solutions contacted you first. Is that correct? Yes, that's right. And you said your communication with them was limited. One meeting, one follow-up? Correct. Can you explain, then, why we have an email from you to Bradford Solutions HR Director, sent within hours of your daughter filing her complaint, in which you initiated contact and offered to provide background information about her? The courtroom goes quiet. My mother blinks. I may have reached out to clarify that they could contact me if needed. That's different from what you testified earlier. Claire's voice is calm, factual. Would you like to revise your testimony? My mother's attorney objects relevance. The judge overrules. The emails are directly relevant to witness credibility. Claire introduces the first email as evidence. The timestamp is projected on a screen. The jury can see it clearly, sent 12 hours after my complaint was filed. My mother stiffens. This isn't going how she expected. Claire introduces the second email, dated 3 days before my termination. She reads it aloud. Confidential. Additional concerns re. Harlan. I think you should know she's made similar accusations at previous jobs. This may be part of a pattern. Claire looks up from the document. Mrs. Taylor, you wrote that your daughter made similar accusations at previous jobs. Can you provide details about those other accusations? My mother's face flushes slightly. I was speaking generally about her tendency to perceive problems. But you specifically stated she made accusations at previous jobs. Which jobs? What accusations? I don't recall the exact details. Because it didn't happen, did it? Claire's tone remains professional. Your daughter has never filed a harassment complaint before this one. You fabricated that claim to damage her credibility. I may have been mistaken about. You weren't mistaken. You lied in writing to ensure this company would terminate your daughter instead of investigating her legitimate complaint. The plaintiff's attorney objects strenuously. The judge sustains the form but allows the questioning to continue. Claire introduces the third email, the one where my mother volunteers to testify. Then the fourth, where she asks for updates on the company's strategy. Each email shows deeper involvement than she admitted. Each timestamp contradicts her sworn testimony. The jury is watching her now, not sympathetically. One man in the front row has his arms crossed. The woman who cried earlier looks confused, betrayed. My mother tries to explain, to provide context, but Claire cuts her off with facts. Dates. Exact quotes. Undeniable records. Claire introduces another message, this one sent a week after my termination. My mother had emailed Bradford Solutions asking if there was anything else she could do to help, offering to review documents or speak with their attorneys. Mrs. Taylor, you testified that you wanted to stay out of this situation as much as possible. Does this email reflect someone trying to stay out of it? My mother hesitates. I was trying to be helpful. Helpful to whom? Your daughter or her former employer? To everyone. I thought. You thought your daughter's complaint was damaging to a company you'd never worked for, so you worked to discredit her before any investigation took place. Claire's voice hardened slightly. You coordinated with her employer to ensure she'd be fired instead of believed. That's not. Then what would you call it? The silence stretches. My mother has no good answer, because there isn't one. The emails speak for themselves. Claire lets the question hang, then asks permission to show the jury the timeline. One by one, the emails appear on the screen with my complaint and termination marked for reference. The pattern is undeniable. My mother initiated contact immediately, maintained ongoing communication, provided false information to justify my firing, and volunteered to testify against me. All while claiming minimal involvement. All while positioning herself as a reluctant witness. The judge is writing again. But this time, I don't think it's helping my mother's case. The plaintiff's attorney requests a sidebar. The judge signals them forward. I can't hear what they're saying, but my mother's attorney looks agitated. When they return, the judge addresses my mother directly. Mrs. Taylor, I'm going to give you one opportunity to clarify your testimony. Were you aware when you testified this morning that your previous statements contradicted the documentary evidence now before this court? My mother's hands grip the arms of the witness chair. I may have misremembered the exact sequence of events. This isn't about sequence, the judge says flatly. This is about whether you told the truth under oath. Did you initiate contact with Bradford Solutions, or did they contact you first? A long pause. Then, quietly, I contacted them first. And did you limit your communication to one meeting and one follow-up as you testified? Another pause. No. I maintained contact throughout the process. Did you provide false information about your daughter's work history to damage her credibility? I believed I was providing helpful context. That's not what I asked. The judge's voice is stern now. Did you tell Bradford Solutions your daughter had made similar accusations at previous jobs, knowing that claim was false? My mother looks at her attorney, who can't help her. She looks at the jury, who are watching with expressions ranging from confusion to disgust. Then she looks at me for the first time since taking the stand. Yes, she whispers. I said that. The courtroom feels different now. The energy has shifted from sympathy to suspicion. My mother sits in the witness box looking smaller than she did 2 hours ago. Her confidence is gone, replaced by something like panic. She tries to explain that she thought she was helping, that she was worried about me, that she didn't understand the legal implications of her involvement. But explanations don't erase lies. Claire asks one final question. Mrs. Taylor, in all your communications with Bradford Solutions, in all your efforts to provide context about your daughter, did you ever once ask her what actually happened? Did you ask about her complaint, about the harassment she reported, about why she felt she needed to document her supervisor's behavior? My mother's eyes fill with tears.
No.
Why not? I thought I already knew. You thought you knew better than she did about her own experiences? I thought I was helping her. By getting her fired? Claire's voice is quiet but sharp. By lying to a corporation so they'd have justification to terminate her instead of investigating her harassment complaint. My mother doesn't answer. She can't answer. Because there's no answer that makes her actions defensible. The judge excuses her from the stand. She stands unsteadily, walks back to her seat, and doesn't look at anyone. The jury is watching her the whole way. And I realize that my credibility isn't the issue anymore. Hers is. The jury deliberates for 3 hours. When they return, the verdict is unanimous. They find that Bradford Solutions wrongfully terminated me in retaliation for filing a harassment complaint. They award compensatory damages for lost wages and benefits, plus additional damages for emotional distress and reputational harm. But the verdict includes something unexpected. In the findings section, the jury specifically notes that witness credibility was a determining factor. They cite my mother's contradicted testimony as evidence that Bradford Solutions had coordinated with outside parties to manufacture justification for my termination. Her lies didn't just hurt her credibility, they proved the company's intent to retaliate. The judge reads the verdict with no visible emotion. Bradford Solutions attorneys look stunned. My attorney squeezes my shoulder. And my mother sits in the back of the courtroom, her face pale, realizing that her attempt to control my narrative has destroyed her own credibility instead. The judge sets a date for motions regarding attorneys' fees and costs. He notes for the record that the court takes seriously the issue of false testimony and that this matter may be referred for further review. My mother's attorney goes pale at that. Perjury isn't just embarrassing. It's criminal. As the courtroom empties, I don't feel victorious. I feel tired. But I also feel something else. Validated. The system worked. The truth won. And I didn't have to scream to be heard. 3 months after the verdict, my career has quietly rebuilt itself. I accepted a position at a smaller consulting firm that values competence over politics. My new supervisor is professional, respectful, and has never once asked about my personal life beyond casual pleasantries. My colleagues treat me as exactly what I am, a skilled consultant with relevant experience. The lawsuit settlement came through. Bradford Solutions paid the full judgment rather than appeal. The money covers my legal fees, my lost income, and enough extra that I can breathe for the first time in a year. But more important than the money is the record. The case is public. The verdict is public. Anyone who searches my name will find not just that I sued my employer, but that I won. That a jury believed me. That my mother's attempt to discredit me failed spectacularly. She's tried to reach out twice. The first time was through my sister, asking if we could talk. I said no. The second time was a letter, explaining that she never meant to hurt me, that she thought she was doing the right thing, that family should mean forgiveness. I didn't respond. I don't owe her forgiveness. I don't owe her conversation. I don't owe her another opportunity to rewrite what happened. What I owe myself is the space to build a life where my experiences belong to me. 6 months after the trial, I'm having coffee with Claire, my attorney, who's become something like a friend. She asks if I ever regret letting my mother testify. I think about it. No. I say finally. If we'd blocked her testimony, she would have spent the rest of my life claiming she could have explained everything, that I was afraid of the truth. This way, she had her chance. She said everything she wanted to say. And the jury heard it all, then chose not to believe her. Claire nods. The truth has a way of surfacing, doesn't it? It does. Not always immediately, not always loudly, but eventually. My mother testified against me with confidence and conviction. She thought her version of my story was more credible than my own lived experience. She was wrong. And now that wrongness is part of the official record. I don't speak to her anymore. I don't explain or justify or defend. I just live my life, make my own choices, tell my own story. She spent years trying to shape my narrative to fit her understanding. She didn't realize that narratives built on lies eventually collapse under their own weight. The evidence she hid didn't just destroy her credibility in court. It ended her authority over my life completely. And I walked away knowing something she'll never understand. You don't need volume to prove the truth. You just need patience, documentation, and the willingness to let facts speak louder than family loyalty.